We are ready to proceed, my lord.
Mr. Morgan, when we closed on Wednesday, there was an objection and the ruling is made. The objection about the questions put in cross-examination. The gist of the objection was that during cross-examination, the DW2 was asked questions about his retirement, his appraisal, and why he was still occupying physical office space at a government institution even after his retirement. It should be noted that during his examination in chief, Dr. Njivwa testified that he retired from government service in December 2023. The defense cited sections 145, 147, 2B and C, 148, 149, and 150 of the Evidence Act in support of their assertion that the questions the prosecution was putting to the witness were insulting, indecent, and scandalous, and aimed at injuring the person of the witness. The defense, in particular, questioned the relevance of the questions to the evidence of the witness. Section 145 of the Evidence Act provides that when a witness is cross-examined, he or she may, in addition to the questions hearing before referred to, be asked any questions which tend to test his or her veracity, discover who he or she is and what is his or her position in life, or questions to shake his or her credibility by injuring his or her character, although the answer to those questions might tend directly or indirectly to discriminate him or her, or might tend directly or indirectly to expose him or her to penalty or forfeiture. Section 147 provides that court will decide when questions shall be asked and when the witness shall be compelled to answer. That is section 147.1. Section 147.2 provides for when court shall use its discretion to disallow certain questions, and these are instances where such questions are improper if the imputation which they convey relates to matters so remote in time or of such a character that the truth of the imputation would not affect or would affect in a slight degree the opinion of the court as to the credibility of the witness on the matter to which he or she testifies, or such questions are improper if there is a great disproportion between the importance of the imputation made against the witness's character and the importance of his or her evidence. Section 150 of the Evidence Act prohibits indecent and scandalous questions, while Section 151 of the Evidence Act prohibits questions intended to insult or annoy. 12th edition of the Black's Law Dictionary defines scandalous as grossly disgraceful and disreputable, inducing condemnation or reprobation by reason of flouting minimal standards of decency and propriety. To annoy simply means to irritate, bother, or disrupt someone's peace of mind and make them unhappy. Determination of the objection. Court has looked at the following. DW2 testified that he is a pro bono lecturer in Makerere University, Department of Pathology, having retired from civil service in December 2023, and that he sits at B27, Department of Pathology, College of Health Sciences, Makerere University. In cross-examination as provided by Section 145 of the Evidence Act, questions can be put to the witness to test his veracity, discover who he is, and also check his credibility. However, as provided in Section 147.1, court will decide when questions shall be asked and when the witness shall be compelled to answer. Section 147.2, which has already been referenced above, offers guidance to court in determining when questions shall be asked. Court is required to make a call on whether the question impacts on the witness's credibility and his character in relation to his evidence. Considering the above provisions of the law, it is the ruling of this court that in all questions put to PW2 in cross-examination, the prosecution is required to demonstrate that there is a nexus between the importance of the imputation made against the witness's character by the question and the importance of his evidence. That will help guide the court in determining whether the question falls under any of the provisions under Section 147C.
Good morning, Doctor.
Good morning, Counsel.
Just testing your microphone to see what, where. Doctor, I believe you are aware that you are still bound by the oath you took last Wednesday.
That's right, my lord.
And just to set the record clear from our viewpoint, by reason of prosecution exhibit 129, if it may, I use mine, 129. We can say on the time. It's the same as mine. 129 is the
In the next court, users for suggestions.
So 129 is the request letter from KAA. From your testimony, you received the postmortem, the sole document supplied to you, which is the postmortem report in that exhibit on the 6th June 2024.
That's right, my lord.
And again, to refresh your memory, let me ask it.
That one is spoiled, my lord.
Refresh your memory. You remember checking your phone to confirm the date when you received the additional requested information, including the photographs. That is on the 9th October 2025.
That's not correct, my lord.
I'm not asking counsel, my lord. I'm asking the witness.
No,
You can't object.
Just a moment. What is the objection?
The objection, my lord, is that what the witness said he received in October 2025 were the soft copy pictures, not the additional documents. Now, my colleague is saying the witness testified that he received all the other documents in October 2025.
You said on the phone.
On the phone, what he received, my lord, were pictures. That's what the witness said. The soft copy pictures, not all the additional documents, the disclosures. So that is, my lord, the record I want to correct. It's factual. The witness never said that he received all the additional documents on the 25th of October 2025. What he received and what he said, what he received in October 2025 were the soft copy pictures and they are on his phone. But the additional documents, he had received them earlier after his first opinion. That's what he said.
We can review the record because what I have is this particular section he mentioned after, if we are to go by the letter of instruction after it was tendered in, then he's indicated that he retired in 2023. And then when we move further, he said, I verbally asked for documents from Mr. Katanga, disclosures from the DPP, and the color photographs. 2 box files were delivered to me by Mr. Katanga, and soft copies were sent to me on my phone. That's what I recall.
Okay, my lord, if you may guide us on the record. But I shall also request court that my lord, the witness be left to answer without being prompted assistance. The witness can always say that is true, that is not true. That's why he took oath.
Recorded. When I asked Mr. Karuranga for additional information verbally, I asked for the following. A, disclosure, in this case B, colored post-mortem pictures. The additional information I asked for was delivered to me in 2 box files, and soft copies of the post-mortem pictures were sent to me on my phone. The post-mortem pictures were sent to me on my phone on 9th October 2025. When I was first instructed, I deemed that an additional information required, that I needed additional information for my professional. So on 9th, there were soft copies. The post-mortem sent to the phone on 9th October.
But may I just request that court continues downwards on that way?
I'll continue with the...
Yes, my lord. Yeah, follow-up questions.
When I was first instructed, I deemed that additional information was relevant for my professional opinion. The witness is given his first report, PX126. I nonetheless went on to form an opinion even without the additional information I considered relevant. Apart from the additional...
So, Dr. Nzua, you are the witness here, and it is okay for you to clarify, including if you wish or have reason to change from your earlier position.
Now, what are we recording now?
No,
after that clarification.
I'm asking the question now.
Yeah, my lord.
I've not asked you any
okay.
questions.
Oh, okay.
So, you first received these photographs of the deceased on the 9th of October 2025. Is that correct?
That's correct, my lord.
I would be correct to say that by the time you are generating your report, which is Prosecution Exhibit 28, the first report dated 3rd July 2024, you did not have the photographs.
No, my lord, I didn't have them.
Okay. Now, on this question of you being a head of, did you say head of City Mortuary or Mulago Mortuary?
I said City Mortuary.
City Mortuary is different from Mulago Mortuary, correct?
Correct, my lord.
Mulago Mortuary is managed by Mulago National Referral Hospital, correct?
Correct, my lord.
And the City Mortuary is managed by the Kampala Urban Authority, KCCA, correct?
Correct, my lord.
So it is correct to say that these two entities, though all located in Mulago, they are run under distinct managements, correct?
Correct, my lord.
First, I used to be always advised. You have never worked for the KCCA or the Uganda Police, have you?
No, my lord.
Who appointed you to head the mortuary?
The Department of Pathology, my lord.
Department doesn't appoint, individuals appoint. Takabega, allow me to cross-examine this. I will, my lord, I'm not guarding the witness. I am the one asking. Mr. Kavega cannot determine how I ask, my lord. I am not gagging. I am just guiding the witness to precisely answer my question. So when he says,
I believe that once counsel puts the question, even if he doesn't want the answer being given, he should relate the answer to be on record. Then he can rephrase and put another question, not to stop him from giving his answer.
my lord, I'm actually surprised that Mr. Kavega is now agreeing to what we were telling him to. You know?
Mr. Morgan,
No,
ask your
yeah,
question.
let me ask him. Please humbly allow us to cross-examine. Please, doctor, if you feel that my questions are unclear or I am being unfair to you in any way, please raise it to the court. Okay?
That's right.
Raise it to the court.
Yeah.
We have full confidence that you carried your abilities to this court. Okay? So the question is, who appointed you? And I'm referring to an individual officer in whichever capacity that signed your appointment letter.
Yeah. My lord.
You can extend that
Yeah.
picture that you don't see.
My lord, it would be prudent for me to explain.
Mr. Onzibua, who?
No.
The question is clear. Who? Do you know who appointed you?
Mr. Morgan, you want the witness to answer exactly who appointed.
My lord, that is the question. I'm not asking for explanations.
Dr. Perhaps you can state that
Yeah.
you were not appointed by an individual.
Maybe.
That's right. I was not appointed by an individual, but voted by the pathologists.
I'm going now to ask you to clarify whether you have any instrument appointing you to head that government facility called City Mortuary. Do you?
We have never had instruments.
Please speak for yourself. Others do.
Yes, we don't have instruments. In my experience there, in the Department of Pathology, we would just ask somebody to head.
We don't have instruments appointing anyone to head.
No, we don't have instruments. We just request somebody to head.
Pathologists would among themselves.
That's right,
choose
my lord.
someone.
That's right.
So who chaired that meeting where you were?
Yeah.
Was it in a meeting? Was it in a conference?
That's right.
Who chaired it?
Late Professor Bimenya, Gabriel Bimenya.
When?
I don't have the exact dates in my mind.
You have the year in mind.
Around 2018.
2008.
2008. Yeah.
And you were, according to what you are telling me, for how long did you act as head? Did you head?
Yeah, that's right. I headed from around 2008 to about 2013.
Are you familiar with somebody called Dr. Barunji?
That's right, my lord.
You work with him?
That's right, my lord.
Where did you work with him?
I worked with him in the Department of Pathology, Makerere University.
Dr. Barunji was head of City Mortuary from 1980 up to the year 2011. Is that a fact in your knowledge?
No, it's not a fact.
What?
1980, 2011. Dr. Zbua, do you know who headed City Mortuary between that period, 1980 and 2011?
Yes, I do.
Who headed the City Mortuary?
Dr. Nsereko Mukasa, from whom I took over. That's right, I know him.
He has been the head of the City Mortuary from 2011 to date.
That's not right, my lord.
What is not right is that fact.
My lord, Council is confusing Director of Medical Services of Uganda Police with a person heading the City Mortuary.
Dr. Nzubua, who is heading the City Mortuary today?
Today, I don't know.
When did you last know the head? We need to write, okay, I'll slow down. When did you last know the head of the city mortuary?
My Lord, when I left.
Okay, so by 2023, who was heading it?
By 2023, I said, that's when I left.
Yes.
There
so
were radical changes in that mortuary.
my question is, yeah, Mr. Yarmanga, we have, Mr. Dr. Mpua, we have about several questions.
That's
So
all right.
please,
That's okay.
you will do this court a favor by answering directly so that we move.
Okay.
You say you last knew the head of the city mortuary when you left. And this court has information you left in December 2023, right? So by that time, who was heading it?
My Lord,
Do you know or you don't know?
I retired in 2023.
Yes.
That does not mean that I know what was going on in the city mortuary after 2013.
So since did you last know the head of the city mortuary? You know, that's the question where I came from.
I said, my Lord,
When
I
did you last
don't know. I knew myself in 2013 when I
So-
was the head.
So from yourself, you know no other head of the city mortuary. I want to leave this.
That's right.
So I will be correct to say that if you ever headed this place at all, my instructions are otherwise, but you never handed over to any officer from what you are telling court.
No, I didn't hand over to
You
anyone.
just marched away.
I didn't march away. We were chased away.
So will I be correct to say that you don't know the operations of the city mortuary since which year were you chased away?
2013.
2013. Will I be correct to say that you don't know how that place operates since 2013?
No, my Lord.
You have no idea who works there and how they work.
My
You?
Lord, I don't have any formal information to that effect.
So is the answer that since 2013 when you were chased away, you don't have any information?
That's right.
As to who works there and how they work.
Yeah, I don't have any formal information.
I'm not going to ask you for rumors. So I will restrict you to what is formally your knowledge. So when you said this place has endemic problems, and all the rest that you characterized the workings of this city mortuary, you are referring to the period when you worked there.
I am actually referring to the period after I left there. Not only me, but the senior pathologists.
Talk about yourself. You are the witness.
That's right, but I know my colleagues were also chased.
You were chased from the city mortuary because you were among the group that was not formally established there. You were passing out and you were there without any formal instructions. That is why you were chased out of that place.
That's not right, my Lord.
Dr. Nzvua, do you hold any formal instructions? You have any formal instructions that placed you or assigned you to do any kind of work at that government facility?
That's right. Yes, I do.
Which one do you have?
My appointment letter as a pathologist.
No. I'm referring to assignment of duties at the city mortuary. Please kindly, doctor.
Yes, I did at that time.
Which one did you have?
The timetable that was produced by the Department of Pathology.
So other than what you refer to as timetable, you don't have any other form of posting instructions to that facility, government facility?
No, none of us had. Me and others. That was the practice.
Dr. Nzvua, I will still through court kindly request you to speak about yourself and don't blackmail your colleagues. Some of them have a name to protect. Concentrate on your issues. I don't want to ask you about other people. I want to ask about you before this court.
My Lord, I want to tell the court the reality.
My Lord, may he be advised to tell this court the reality about him, not other people.
Yeah.
Objection, my lord. I think my colleague can only ask questions. The witness is at liberty to answer questions, including other people. But you can't limit him and say your answers should only limit to you. He wasn't working in the forest. He was working with others. So I think my lord.
We're asking the witness about him and what he can verify. The others are not here.
My lord, can I finish? Can my lord accord me a minute to finish? Okay. Thank you, my lord. So, my lord, my colleague can determine questions to a witness. He cannot determine the answers. Even when he doesn't like those answers. When he asked Dr. Nzvua and said, how are you working in Mulago? And he says, that's how I used to work with Dr. So and Dr. So. You can't say, no, don't mention those doctors. And at the same time, ask him about other doctors. Tarugara, Birunji, and everybody. You can't determine your questions, my lord. You cannot determine the answers the witness gives.
But in this instance, Mr. Mwebas, they're asking him about his posting instructions.
Yes,
let him talk about his posting instructions. When the question requires him to talk about others, that is how the question will be. They've asked him, do you know Dr. Barunji? Do you know Dr. Biaranga? On this one, let him talk about his posting instructions.
Yes, you see, my lord, what I am avoiding is for the witness to be given a tunnel within which to walk. You can't say, don't say this, but say this. Then why are you asking questions? Let him say what he wants to say.
Mr. Tumwebas, the witness will answer the question on his posting instructions.
Yes. Because he wasn't working in isolation.
But they asked him, do you have posting instructions? Yes. It is him who is giving evidence, not the others.
Thank you, my God.
Court will note that the witness stated that they do not have posting. He does not have any posting instructions with the city mortuary.
And my lord, it is irrelevant when you ask me whether I have a certificate of P7, and I tell you when I sat in 1960s, P7 never used to issue certificates to all of us. So it's not only the me who doesn't have a P7 certificate in 1960s. So it's irrelevant.
Please be seated.
Dr. Nzvua, we shall now move to something else. As a forensic pathologist, are you aware about the rule on sub judice? That's something new to you?
I am not a lawyer.
That's why I'm careful to ask you as a forensic pathologist.
I will need guidance, my lord.
My question is, do you know or you don't? I don't know what guidance you want court to give.
Maybe explain to him what sub judice is, so that
My Lord, may I request that he states whether he knows or not? Then I will proceed to that enlightenment. My question is, I kindly listen to how the words come from my mouth. They are on purpose. Okay? My question is, as a forensic pathologist, do you know about the rule on sub judice?
I do not know, my lord.
Sub judice, this rule means that when a matter is still pending determination in court, it should not be a subject of public debate. Are you hearing this for the first time?
I understand this now.
You now understand it.
From you, yes.
Are you understanding it today, or this is something that has been in your knowledge as a senior pathologist, a senior consultant?
Yeah. I have always known.
Okay. Doctor, confirm that telephone number 0772 41 40 40 is your personal telephone number.
That's right, my lord.
I want you to confirm that you are a member of a media platform called Pathologist Uganda. Are you?
That's right, my lord.
At about 7:16 p.m. on Wednesday when you left this court, you posted your third opinion, what you called the third opinion, which is the PowerPoint presentation on that group, correct?
That's right, my lord.
what was the time again?
I wrote 7:16 p.m. I want to save time and give you an extract of what you posted. Can you go to the second page where you see your number?
That's right, my lord.
Confirm the time you posted it.
7:16 p.m., my lord.
What caption did you put to your PowerPoint presentation before this court?
This,
Court.
yeah, this was the presentation in court today.
What else did you say?
A prudent doctor knows when to consult and when to refer.
You confirm that that is what you posted.
That's right.
Please give it to us. I pray to have it in as an exhibit.
My Lord, we object to the tendering of this document. And the rules of tendering electronic evidence should clearly apply. While the witness has confirmed that that is his phone number, the person who took this picture should be here. The phone should be here. And we examine it because of the possibility to insert. So you don't take a screenshot of the message I sent to you and pass it on to a lawyer, and then the lawyer brings it to court the following morning just because I sent you a hi. The person who did should come here. The phone should be before court. We should be able to cross-examine them, not him. He's on a professional group. They were discussing from the messages I see, they were discussing his day in court and advising each other as doctors, as pathologists. Because it follows by saying, I agree, there seems to be 2 or 3 pathologists only allowed in Uganda, that's how it continues. So my Lord, whoever, those other messages, when you pick it in isolation, you don't get, the entire conversation is very good. Actually, we would be happy if the doctor who did it comes. We would be happy to have it because it seems to be a very interesting discussion between these pathologists. Very nice. But my Lord, the rules of tendering electronic evidence should apply to this document. This witness is not the best witness to tender it here. He is not the author. There seems to be about 10 messages on these pages. There are 10 messages. Dr. Ozvua only has 1. All the others are by other doctors. I don't know when you read section 8.2 of the Electronic Transactions Act. It says a person seeking to introduce a data message or an electronic record in legal proceedings has the burden of proving its authenticity by evidence capable of supporting a finding that the electronic record is what the person claims to be it.
Just a moment.
For it
Seeking to introduce a data message or an electronic
or an electronic record in legal proceedings has the burden of proving its authenticity. So we don't know whether this was printed from my colleague Mwaganya's phone or not. Its authenticity by evidence, so you prove by evidence, capable of supporting a finding that the electronic record is what the person claims it to be. So we will need evidence to prove that this is what my colleague Mr. Mwaganya claims it to be. We can't just have screenshots, my lord. So we can't even know, my lord, and that's what is important, whether the person who passed on this one to him is on the group. We would be happy he's on that particular group of pathologists, Uganda. If we get the person who passed on the message with his phone and we have him, then that's, my lord, very good. Because I like the discussion. It's very professional. It is informative. It tells us that there are only 3 people allowed to do autopsies in Uganda, only 3. But now we don't know. We don't know whether it's by a hacker. Some hacker could have hacked into the pathologist group and inserted some messages. We don't know. But fortunately, the witness has accepted that when he left, he shared his finding with his colleagues in a professional group. Just like we could share submissions in a lawyer's group. You can't use them against me. So when he has gone over the hurdle of that section, then my lord, we can consent to it, and then we even re-examine our witness on it. You must first go through the hurdle, proving then we solve it. Of the Computer Misuse Act, it is unauthorized access by what my colleague is trying to do. Is unauthorized access of the WhatsApp group of pathologists and a lawyer in the DPP's office. We seem to be witnessing a crime being committed in court now. Clearly, I don't know who will charge him because he's the one charging people, but my lord, we seem to have a crime. We are in the middle of a crime scene now. My lord, even 7 is informative. Section 7 of the Electronic Transactions Act. It is headed Authenticity of Data Messages. Authenticity of data messages. The long one has A and 1, where a law requires information to be presented in an original form. The requirement is fulfilled by the data message if A, the integrity of the information from the time when it was first generated in its final form as a data message or otherwise has been passed assessment in terms of subscription to, and that the information is capable of being displayed or produced to the person to whom it is to be presented. And 2, for the presumption of section 2, the authenticity of the data message shall be assessed A, by considering whether the information has remained capable or unaltered, and then B, in light of which the information was generated. In light of the purpose for which the information was generated, that is B. In light of the purpose. The purpose why Dr. Ezurua generated this and sent it to his first group, what? WhatsApp group of pathologists. What was the purpose? The much obliged, my lord.
My lord, we shall restrict our reply to only the legal issues, not the issues of evidence that appear to come out of Katanga. My lord, what is being sought to be tendered is a document, not an electronic message. Once a message is printed and reduced into a document, it ceases to be electronic, it becomes a document. It ceases to be a data message, my lord, I beg your pardon. It ceases to be a data message and it becomes a document. And so the rules then govern, the rules that govern the tendering of that exhibit cannot be the Electronic Transactions Act, but rather Evidence Act. So with due respect, the section 7 and 8 being quoted by Learned Counsel are inapplicable. My lord, under the Electronic Transactions Act, section 2 is the interpretation section, defines a data message to mean data generated, sent, received or stored by a computer. And may include voice, where the voice is used in an automated transaction, and stored records. My Lord, we are not seeking to tender a data message, either voice or a video, or a message still stored in a computer. We are seeking to tender a document in its physical form. My Lord, it should be noted that all documents are first generated through electronic devices, which are otherwise called computers. But once a document is printed out, then it ceases to be electronic. It becomes a document. Section 2 of the Evidence Act specifically 2 subsection 3, my Lord, which defines documentary evidence. Documentary evidence, my Lord, means all documents, explicitly, my Lord, all documents produced for the inspection of the court. The law doesn't, my Lord, distinguish the manner or process of generating the document. That all documents, without reference to the process, how they were generated. So in this case, my Lord, the witness has been explicit. He has identified the document. He has acknowledged his telephone number. He has also confirmed that what it represents is what he posted on that particular platform. Has not denied or cast any doubt either regarding what he posted or the accompanying captions. He has not even insinuated, as counsel seems to submit, that anything was inserted or that anything is incorrect. To that extent, my Lord, and this being cross-examination, the document should be accepted on record. And in this case, my lord, not necessarily to prove the content per se, not about content, but proof of the fact that the witness posted the material on a particular platform. It can only be him, my lord, to confirm or dispute. And he cannot confirm, and there exists a justifiable reason to reject admitting it on record. So pray. The application was mine. He objected. I rejoined.
You rejoined, but we
My
believe
Lord,
of
can I
court.
be of court just
Yes.
1 minute? Much obliged, my Lord. My Lord, my learned colleague started by saying he intends to tender a document, this, and not an electronic message. He said, I intend to tender a document, not an electronic message. And he went to the definition section of the ETA, the Electronic Transactions Act.
That's the one they intend to
He
tender.
says he intends to tender a document, not an electronic message. That was his opening statement. Then he went to section 2 and read the definition, that is the definition section, my lord. He read the definition of data message. My lord, our objection is on the definition on the electronic record. We contend that this is an electronic record. And my lord, the electronic record is defined in that very section. So he read one definition and left another. My lord, section 2 defines electronic record system as following. Electronic records, and electronic record, electronic record as this, my lord, and this is the definition section. Electronic record.
My lord, with your indulgence, I thought that if our colleague wants to rejoin, he can only rejoin on what we have submitted.
But
It is introducing new matters.
My lord, this is the definition section, section 2, which he made. I'm on section 2. Yeah, it says it, my lord. I'm just reading for you the definition. No. The Transactions Act, my lord, you read section 2. You read section 2, the definition. No, it's not system, it's electronic record. Not system, my lord.
Transaction, section 2 defines a database sent, mean data generated, sent, received, or stored by.
I only restricted myself to electronic data, not systems.
No, my lord, I said, my lord, sorry, I'm not going to systems.
Where the voice is used in an automated transaction and stored.
And my lord, I'm within that same section 2.
Section 2, and you're talking about electronic record.
My lord, I'm saying our objection was on electronic record, not electronic message. And I am going to the definition section because he read one part and then to go to the other. And electronic record in that definition section is defined. It means data which is recorded or stored on any medium in or by a computer system or other similar device that can be read or perceived by a person or a computer system or other similar device, and includes, I wrote underline, display, printout, or other output of that data. A printout. That is the definition of the electronic record in that same section 2. It includes a printout. It means data which is recorded or stored on any medium in or by a computer system or other similar device that can be read or perceived by a person or a computer system or similar device and includes a display, printout, or other output of that data. Output of that data. Whichever way you output that data, the computer record. And then section 6, again 8, tells you, even H6 and H2, H6 tells you how you can whatever it, how it can be delivered. H6, my lord, says you must follow the procedure. H6 tells you what procedure to follow if you want to deal with that electronic record.
Lord, on the new matter, he has just raised is we seek for your indulgence because it is introducing a new matter and in a way that is misleading. Let me just be allowed one sentence. If this court was to go by his interpretation, then no document would ever be tendered as a document. Because, my lord, all documents, books, newspapers, mention it, they are originated through a computer. So if we were to go by that interpretation, my lord, all documents would be regarded as electronic, as electronic data or electronic record because they were printed through a computer system. That would be misleading. And that's all that we have to say.
Mr. Morgan, are you able to move to another matter?
Yes, my
For
lord.
now, we will come to this after the break.
No problem.
Because I'll need to go through all the different provisions.
Absolutely.
And make a decision. So we will stand over this particular matter and move on to. Kino kyalero kino atugambira kyakimanya nti ali hansi y'okurahira okuyakoze ekiro kya kasatu okutabaire hano kandi nti akakora ekyandiiko kye ngire kyabanize omwezi gw'omukaaga ekyandiiko kyakoze by'okwezi bisatu ebisale bino akaba takabitungire kandi ye town enkotene ya Kampala okumarra eri ekwawukana hali eyahulo lya mulago kyonka ababikuura nibawukana n'obusobozi obubitwara bukwawukana kandi takakorahoga orubuga runo lwa Kampala nobwakubaire ekitongole ekya poliisi wenka omuntu ata omulimu gwa muhairo gwakora okakaba nakora mu kichweka kino kandi kitegeezebwa nti tibalina obusobozi tibalina rundi kikoleka nti haliho obusobozi obubaheereza emirimu baitu bakomwa kati bamuha obusobozi okukuura ekicweka kino okuloga omwaka gwa 2008 kwika omwaka gwa 2013 abadaktari abamu abaizire nibagambwaho akubamanya agamba nka Dr. Bironge ayakolire mulago na daktari akwetebwa Byaruhanga obutukumanya nti luwe hati akukuura ekikaro kino hali alinakuura baitu ekyatugambire nti ekyo kubuzibwabuzibwa ali mu kicweka kindi kyonka atali mwegyo nyamirimu
confirmed court that the material that you posted also included the colored photos of the deceased as they are represented in this document baptized Defense Exhibit 2910.
Uh,
It,
yes, my lord,
okay,
I can confirm that
okay.
I posted what was already in public domain.
Okay, you will tell court.
Yeah, yeah.
By public domain, you mean what?
What in an open court?
Oh, okay.
What was already in an open court?
The other simple thing I want you to confirm to court is that when you posted it on that social media platform, it generated debate. Did it or did not?
No, my lord.
Was it debated?
It was actually posted because of the previous debates.
Now, I will request you to answer to my question, because I'm not interested in your previous debates. Will you tell this court whether after you posted that report with the photos of the deceased person, it generated debate on the platform? Did it or did not?
It generated more debate.
It generated more debate. Doctor, had you engaged in the so-called previous debate on the matter?
That's right, my lord.
When was that previous debate on the subject?
Can I look at my phone and tell you?
Yeah, I think my lord
Okay.
does. Yeah. And I'm asking when? Doctor, is you to confirm to court that the previous debates were before you came to testify in this court?
That's not right.
Oh, it was after?
Immediately after I testified, the debate started.
Okay, so the debate started when you testified?
That's right.
Okay, then that's okay. You can keep peace with your phone.
Okay.
As a doctor, are you aware that your professional conduct is governed by laws and the professional codes of ethics?
That's right, my lord.
Is it in your knowledge, doctor, that your professional code of ethics prohibits disclosure of information relating to your subjects, unauthorized disclosure of information relating to your subjects?
That's not right, my lord.
So you, as a doctor, you are at liberty to disclose information of your subjects. Are you or you are not?
That's a misleading question, my lord.
Let me repeat it
Yeah.
so that I'm sure you have understood. As a doctor, are you at liberty to disclose information relating to your subjects?
Yes, but when it is a matter of court, you can disclose.
So as a doctor, you are not at liberty to disclose information about your subjects, but if it is a matter of court,
Yes.
you can disclose.
That's right.
To whom do you disclose matters of court? Is it to the court or to the public?
To your colleagues and to court.
Are you in position to guide this court as to the specific court which authorizes you to disclose such matters to your colleagues? You are a senior person.
Yeah. My lord, we don't see.
Are you or you are not?
Again,
For report.
yes.
Yes. Are you in position? My question: are you in position to guide this court to a specific court that authorizes you to make such disclosure to your colleagues?
No, there is no specific court.
There is no specific court. Doctor, are the provisions, specifically section 30, subsection 5, subsection 3 and 5 of the Health Service Commissions Act, in your knowledge? Are you familiar with the, my lord, section 33, subsection 3, and section 30, subsection 5? Are those provisions in your,
In my head,
the Health Service Commissions Act?
no, my lord, I don't have them off head.
Okay. Yeah, that's cool. But are you bound? Do you feel bound by the provisions of this act? The Health Service Commissions
Yes, my
Act?
lord.
You
Yes,
are
my
bound.
lord. Yes, my lord.
With your indulgence, my lord, I request to read these provisions and I put the concluding questions to Dr. Nsbua. Dr. Nsbua, section 33, subsection 3. I'm going to read it verbatim. Please listen. It says, subject to subsection 5 and section 30, a health worker shall respect the confidentiality of information relating to patients or clients or his or her family. Such information shall not be disclosed to anyone without the patient's or appropriate guardian's written consent, except where it is required by law.
Very good.
You feel bound by that provision?
Definitely.
I'm also reading you section 30, subsection 5, which was referred to, and says a health worker shall respect the confidentiality of information relating to patients and his or her family. Such information shall not be disclosed to anyone without the patient's or appropriate guardian's consent, except where it is in the best interest of the patient.
I agree with that, my lord.
I want you, in addition, to confirm to this court that you are bound by the Uganda Medical and Dental Practitioners Council Code of Professional Ethics. My lord, it is the Uganda Medical and Dental Practitioners Council Code of Professional Ethics.
That's right, my lord. I'm bound by it.
I am going to read you the provisions of Regulation 6A. Regulation 6 relates to protection of privacy. And under A, you as a practitioner, you are prohibited without the express consent of the patient, or in the case of a minor, with the consent of a patient or guardian, or in the case of a mentally disadvantaged or unconscious, or, and I emphasize, deceased patient. In terms of deceased patient, without the consent of his or her authorized next of kin, you are prohibited from disclosing information of those subjects. Is this something in your knowledge?
Yes, very much.
Doctor, when you published the photographs of a deceased man called Henry Katanga on social media, did you have this required consent from his next of kin? Did you or you did not have?
No, I did not have.
Will I therefore be sure that your action was of displaying these photographs in that report was unethical, since you did not have that consent?
You are very wrong, my lord. He is very wrong. Because the late was neither my patient or a deceased I worked on. So this, you cannot hold me responsible for that.
My lord, I leave that subject at that, and I'm going to something new. You told this court that when you get your qualifications, you register them with the Uganda Medical and Dental Practitioners Council.
That's right, my lord.
In fact, qualifications of all licensed medical practitioners like you are published for the entire public on the official website of the Medical and Dental Practitioners Council.
I don't know that.
Are you aware, if I wanted to get your record, it is possible to search your particulars on the platform of the council?
My lord, I don't know how accurate those records are.
Do you doubt the accuracy of your regulator, the information provided to the public by your regulator?
I have no reason to doubt it.
You have no reason to doubt it. I want to search for your record, and my requirement is that you confirm to court whether that is a true reflection of your standing in terms of your professional qualifications.
That's right.
My lord, may I request the court assistance to go on the public record and display it in court.
Objection, my lord. The witness was asked, do you give those qualifications to the Uganda gentleman? And he said, yes. Then he asked him, are you aware that they put them on their website? And his answer was, I don't know how accurate those records are. Now what we are doing is that we are pulling out those records that the witness has already said, I don't know how accurate they are. Said, I have no doubt, I have no reason to doubt them, but he said, I don't know how accurate those records are. And now we are pulling them out for him to confirm that they are accurate or not, when he has already said he doesn't know how accurate they are. Can we revisit it?
They are public records.
Yes, my
Of
lord.
the website.
Yes, my
He is
lord.
regulator.
Yes, my lord.
And the witness is here.
Yes, my
He
lord.
has said he cannot know whether they are accurate, but he
Yes.
has no reason to doubt them.
Yes, my lord.
But anyone can go to the website.
Right, my lord.
Please go to the Google search. You type in UMDP, UMDP, Uganda Medical Dental Practitioner. UMDP. Yes. Space. Council. Council like city council, not like yes. No, the other council is C. No, C. No. I-L space register. Yes. When you do that, you will go and search. Type in, please. If you can follow our instructions without you assigning yourself additional responsibilities, do what we are telling you. Register. Have you spaced? Yeah. Type in Onzibua Sylvester. You know the spelling? Ms. Onzibua, how do you spell your name in your records?
ONZ.
What? You go slow.
ONZIVUA.
What? Space? The other one?
Sylvester.
You can even search by Onzibua. There are not many Onzibuas in that council. Add Sylvester. Onzibua, your other one. S.
SYLVST.
Yeah, enter. Let's search. Go down. You are searching in AI. I want, but that we shall still find it. Go down. Okay. Click on find health practitioner. Go to, no, go up. UMDPC, no, there. There where the cursor is, not down, there. Use that. Now go to that search engine, put in Sylvester. UA. Space. Sylvester. Doctor.
It is SYL. Yes, SY.
Okay, then. Doctor, go ahead and guide him.
SYL VELVESTER. Sylvester Stallone.
Just type in. Other things will come. You never told us you had additional names.
No, just to help you with the spelling of Sylvester.
Can you remove Sylvester first? Just search on the board. Can you capitalize board?
When we register, we are given a practicing certificate. We have a registration certificate. Those are the most important things. If council wants them, I can avail them, my lord.
Let's use what is here now. The public record.
I didn't come with it here.
Yeah, that's why we are using what is available. There you go. Doctor, is that you?
Yeah, that's me. That's the photo I supplied.
And this is your regulator.
That's right.
Look at your qualifications. They reflect your true academic standing as filed by the regulator. Take your time. Yes,
One of the assessors.
Oh.
Yes, that is.
Yeah,
My qualifications are, those are okay.
Yeah.
Yes, those are the ones.
But let's wait for the assessor.
Tubaleke tutegereze nti ekiwandiiko kimu akakiteekawo kimbe olwaloho n'abadaktari bangi abakola nabo ekitongole eki kya forum kandi kino kikaleetaho okuyingiza.
Okay, first read your qualifications for the record. You can see them, but you have to be on record. My Lord Assessor is back.
My lord, my qualifications are MBCHB, meaning this is in Latin, but Bachelor of Medicine and Bachelor of Surgery of Makerere University, 1992. M.Med means Master of Medicine of Pathology in 2003. The other one is diploma in forensic pathology, the postgraduate diploma in forensic pathology from the colleges of medicine of South Africa in 2005.
So, which of these three makes you a forensic pathologist?
The last one, my lord.
The postgraduate diploma in forensic
First,
pathology.
that's right, my lord.
And your regulator can only include these qualifications on your professional public portal because you registered them with them. We registered the documents with them.
That's right, my lord.
Your documents before publishing them.
I am not the regulator, my lord. I don't know.
Okay. Okay, I want to sample maybe one more example so that we can compare you and what other results by other people. You want to volunteer who we should sample? Okay, let's sample your friend William Male Mutumba.
That's right.
Type in William Male. That's the William Male Mutumba that you were talking about.
That's right, my lord.
The one who did the post-mortem report that you reviewed.
That's right, my lord.
Are you in position to read the qualifications that are displayed that he possesses?
That's right, my lord.
Okay. What does he possess?
Bachelor of Medicine and Bachelor of Surgery of Makerere University, 1984. Master of Medicine Pathology of Makerere University of 2005.
You go Master of Medicine
In Pathology
Yes.
of Makerere University, 2005.
Yes.
Then Diploma Forensic Pathology, College of Medicine of College of Medicine of South Africa.
Which year?
I can't see well from here.
It's clear even the blind can see.
Our eyes vary.
Okay.
But can I move closer and
Sure.
see? Yeah.
But it is expanded for you for avoidance of doubt.
Oh, okay. 2012.
So, doctor, from an academic point of view, do you possess any superior qualifications than that man called Male Mutumba Williams?
No, my lord.
In fact, the professional qualification for being a pathologist, you are both trained from the same college.
That's right, my lord.
I just wanted to correct the impression that you had, I believe, inadvertently caused, referring to that gentleman as the less of pathologist.
That's not right, my lord.
In fact, Dr. Nzboa, in terms of seniority, Dr. Male is more senior to you. He started practicing medicine way before you became a student of medicine. You qualified in 1984. You qualified in 1992.
That's right.
I now want to do one more thing. Dr. Nzboa. Are you familiar with, again, let me save on the time. I want to read you Regulation 22 of your ethical code of conduct. My Lord, I am in the Uganda Medical Dental Practitioners Council Code of Professional Conduct. Regulation 22, Dr. Nzboa, this is what it says. It deals with professional reputation of colleagues. I believe you know it. You knew it even before coming to this court.
That's right, my lord.
A practitioner shall not unjustifiably cast doubt on the probity or professional reputation or skills of another practitioner. Practitioner shall not unjustifiably cast doubt on the probity or professional reputation or skills of another practitioner. You were in this court last Wednesday, doctor, and you imputed the professional standing of that senior gentleman. Having brought Regulation 22 to your attention, do you regret your imputation?
Absolutely not, my lord.
Lord, again, I will leave that point at that and move to another subject. May I pray that, yeah, thank you, sir. We are done. We can go back.
Lord, we will need this laptop.
My Lord, the laptop is available if Mr. Kaveka can't afford one.
This particular is not a question. It's not a question of affordability. This is the one which council has used.
My Lord,
I don't want to use mine because that hasn't been. Yes.
I know Mr. Kaveka is not may not be IT compliant, but what has been displayed there is not a laptop. It is information from a website. But the laptop is available, my Lord.
I know you used the fourth one and it failed to give us this.
We shall use this one. Don't worry, Mr. Kaveka. Yes. Yes. My Lord, I pray for Exhibit 128 to be passed over to Dr. Nzboa. Doctor, that was your very first report that you issued, your first opinion that you issued in this exercise. Can you read to court the first sentence, paragraph 1?
I acknowledge.
No. Paragraph number 1.
Suppose with the first sentence.
In paragraph number 1.
Oh,
Yes. Up to the word and, then you end there.
okay. The body of the late Henry Katanga was brought to the Kampala capital city mortuary in a private vehicle
Proceed up to officers.
and not a police vehicle or accompanied by investigating officers.
And end there. Okay, maybe you complete the sentence. I'm sorry.
As should have been the case.
My lord, I pray that the post-mortem report is passed over to the witness. You could use the one he used, my lord, which is DE 22. 22. Let's use the one that he worked with. Dr. Nzvua, please take court to the source of this information in the report that you possessed at the time of making this report. Specifically, information pointing to the body having been relayed to the mortuary, not accompanied by the investigating police officers.
My lord,
Is it there?
there is no investigating officer noted here to have accompanied the body, my lord.
Okay. So will I be correct to say that this is extraneous information that you got from other sources, not the report that was before you for review?
No, my lord.
What is the source of this information that you put in your report?
My lord, this post-mortem report.
Okay, take court where you got that information in the post-mortem report. Forget about the vehicle, just go to the fact that the body was delivered to the mortuary, not accompanied by any police investigating officers, as should have been the case.
My lord, it should have been recorded here which police officer accompanied the body. It is not, should have been recorded.
Should have been recorded. So because it was not recorded, you confirmed it as a fact that it was not the case. Is that what you want to tell this court?
No, my lord.
So what informed your conclusion? You are making a statement of fact in your own report. What informed your mind to arrive at this statement of fact?
The post-mortem report.
Where?
My lord, there is no name of a police officer accompanying this body. That's what
Exactly. So please kindly understand my question.
Yes.
So because there is no name of a police officer who accompanied the body, that is what informed your conclusion that there was no police officer that accompanied.
That's right, my lord.
Well, just to put your notice that this court already has evidence of which police officer accompanied the body. Do you regret that you made an incorrect statement of fact as a professional?
From the post-mortem report, I could not have done otherwise, my lord.
Does the post-mortem report indicate that no police officer accompanied the body? It has not, my lord.
Because he said that because the post-mortem report did not indicate which police officers accompanied the body, I made the conclusion that no police officer accompanied the body.
Will I be correct, Dr. Nzboa, to say that simply because the post-mortem report didn't mention that fact, you assumed that there was no police officer?
My lord, I could not assume otherwise.
So you assumed?
I could not assume otherwise.
Okay. That is still fair. And for clarity of mind, Dr. Nzboa, which this court will be correct to conclude that your report also contains assumptions.
My lord, maybe let's be specific on which assumptions.
Okay, you will tell court whether which specific assumptions, but does it contain any assumptions?
Not any more. Not any that I'm aware of.
Apart from?
Not any that I am aware of.
I want you to go to paragraph 2 of your first report.
Oh, I've already done it.
Paragraph. Sorry.
I've already handed it over.
I don't have it.
Okay.
Please return the Is this medium? Please. Paragraph 2. Read it to vote.
The post-mortem examination was carried out and report signed by 2 pathologists, Dr. Male Mutumba and Dr. Ambayo Richard, who are well known to me.
How did you conclude that paragraph? Read the last sentence.
I know for a fact that the 2 ex-pathologists have no specialized qualifications in forensic pathology.
Read it again. You know it for a fact?
I know for a fact that the two pathologists have no specialized qualifications in forensic pathology.
Doctor, with what you have just informed this court in respect of Dr. William Male Mutumba, do you still maintain that this, your conclusion in respect of Dr. Mutumba, is correct?
Yeah, to the best of my knowledge, yes.
Just to remind you, a few minutes ago, you told this court you hold no superior qualification than those of Dr. Male Mutumba. Do you still hold this view at this moment in time?
Of course, with respect to forensic pathology, I still have question marks, my lord.
May I know under what authority you have question marks? You have question marks as who?
My lord, I told this court that I coordinated the training. Yes, as a coordinator of that particular course that Male Mutumba went to attend in South Africa.
Coordinated the course on
That forensic pathology. That Male Mutumba attended in South Africa. Of that group that went, 2 pathologists did not qualify. That time, two of the pathologists that we sent to South Africa did not qualify.
Okay, so Dr. Onzvua, good enough. By any chance, were you any of the instructors of that course?
Yes.
Were you or you are not?
I was.
In South Africa?
No, they started here.
No. That qualification you read to court is attained in the College of Medicine, South Africa.
That's right.
Yeah. Maybe you are mistaken. I'm talking about what you read. He started from the same college that you went to in South Africa. Were you any of the instructors in that university?
My lord.
Were you or you were not?
Yes.
You were one of the
instructors
in that university.
I think you don't understand, my lord. No, it is colleges.
I can assure you that
No. Maybe I need to clarify.
No, maybe
it is
colleges, clear to you.
Colleges of Medicines of South Africa. It's not one college. Colleges of Medicines of South Africa.
That's right.
Yes.
That's right, doctor, for the clarification. This court wants to be very clear with you, Dr. Onzvua. Did you teach? Yes, please.
Yeah.
Did you teach this
Yes.
man in that university?
My lord, for clarity.
In that college, my question is clear, Dr. Onzvua, please.
That's right. I would like to clarify.
Did you teach him in that colleges of medicine in South Africa? This is simple, please.
Yeah. My lord, can I say how this course was conducted?
My lord, you asked for a clarification.
Yes. I need to clarify, my lord.
Yes. Did you teach this man in that college in South Africa?
maybe the witness give us a bit of a background about
Yes.
My lord, I don't require a background in this question.
But my lord, the court
I am
has asked
asking
for it. My lord,
yes, the court will, but my question cannot be modified by Mr. Tumweba.
No, a court has.
No, my lord, I won't allow that. I'm sorry, I am not allowing for.
Mr. Tumweba's
Yes.
Much obliged, my lord.
Let him write.
Court
He
has
has
it for
it.
clarification.
I
Yes.
wanted to know, because
Yes.
you kept asking and saying.
My lord,
So
we
I
shall.
wanted to know how
Yes.
it works, so that we understand.
Yes.
You need to write the respect in which he was aware of how Dr. Mutumba performed.
I shall apply.
And my lord, my learned friend, my lord,
Let us hear.
my lord, this is a question of procedure. We retreated to our chambers the other day, and my learned friend should courteously do what we have agreed in chambers. Yes.
So what value are you adding? What do we have?
That's that.
What?
Now, my lord, that's what we say we are doing.
Defense and prosecution,
That's what we agreed.
give a bit of the clarification.
Please.
How
That-
it
yes.
My lord, I am most obliged. These people won't answer for Dr. Zubua. Dr. Zubua, please answer what the court is requiring.
Yes.
Mr. Tumweba.
My Lord, I designed this program for training Ugandan doctors. The colleges of medicine of South Africa allowed us here in Makerere to do the initial teaching, and the students would only go to South Africa to do the practical part of the exams. The first part they even did here in Uganda. So here I was their supervisor and their teacher. This was in collaboration with the colleges of medicine. They made,
You designed the course.
I designed
It
the
was
course,
in two parts. Part of the training was in Uganda.
right,
The other part was
in South Africa. Yes.
Run by Makerere University.
Yes. We were a satellite college.
My lord,
And,
may I
and-
proceed?
and my Lord, that's how I ended up teaching them. And when the results came out, they were put on the website of the colleges of medicine of South Africa. That's how I knew Male Mutumba did not qualify.
And which year was this?
This was in, I think 2012,
When did you get yours?
2005. And my Lord, with respect to that, we can go to the colleges of medicine of South Africa. The results are still there on the web. We can show it here, whether he qualified or not.
Now, Dr. Zgoa, just a simple thing. By the way, even what you requested is good, and don't mind. We will afford you that opportunity. This court would be interested in knowing, were you part of the decision makers in the College of Medicine in South Africa as to who to qualify and who not to qualify, or you just heard, or you were told that your colleague did not qualify?
On the website where the results are displayed, his name was not there.
You just saw it on the website?
That's right.
Again, because you never saw his name on the website then, that is what led you to assume that he never qualified, correct?
That's right, my lord.
But I just want you to confirm that you are not part of the awarding authority of these qualifications in that college in South Africa.
No, my lord, I am not.
So just to remind you that that is the second assumption that you make in this report. We are now going to the third one. Read the third paragraph.
There was a fundamental error in the identification of the entry and exit gunshot wounds.
Proceed.
Gunshot entry and exit wounds on the skull are identified by the beveling effect of the bullet on the skull. This was not mentioned in the report and probably not looked for and documented.
Now, your closing remarks in this paragraph, you are talking about the probability of your colleagues not looking for it or not documenting it. Just to confirm to court that this is not a finding backed by evidence, but it is an assumption.
This finding is backed by the post-mortem report.
What in the post-mortem report backs this finding? Go straight.
Beveling was not mentioned.
Again, because beveling is not mentioned in the post-mortem report, you assumed that it was not looked for by your professional colleagues who authored that report, correct?
Such an important
Correct
thing.
or not?
Such an important thing.
Is it the reason why you assumed, please, doctor?
Yes?
Okay, please, let's move.
Yeah, okay.
So that is the third assumption in your report. We are going to another one. Please, doctor, go to the fourth paragraph.
There is no doubt. There is no.
That is number 5. You go to number 4.
Oh. The entry and exit wounds should have been identified at the post-mortem examination and then swabbed for gunshot residue. There is no record of this having been done.
Doctor, I carried your record here in this court, but without us wasting a lot of court's time, this is the first case involving gunshot injuries to the head that you testify, you appear to testify in the High Court. Correct?
That's not right, my lord.
How many cases of gunshot to the head have you ever testified in?
My lord, the Godi case, I
How
went and
many? I'm
reflected.
looking for a number, doctor. Don't volunteer too much. Answer my question.
I don't know how many.
So the answer is you have testified in several cases.
In several cases, yes.
Gunshot injury
Yes.
to the head.
The Godi one, yes, there was one to the head.
Do you want to, Godi is a public record. Do you want to go and record that Godi case was gunshot to the head? It's a public record.
Yeah. My lord,
Do you want to go and record
yeah,
that
that's
the Godi
true.
case was gunshot injury to the head?
There were 2 gunshot wounds.
Uh,
There were 2.
Was one of them to the head?
Right.
I'm not conceding that it is correct, but it is on record, okay?
That's
so
right,
I don't
my
have
lord.
to bother much, my lord. The
Okay.
only case is a public record. We will traverse it. So other than that, do you remember any other in your entire career?
My lord, I need to think backwards.
So you can't remember any other.
I have done too many postmortems.
Dr. Nzvua, do you just remember on Thursday, you told this court that you only had an opportunity to testify once in the court martial and not in the High Court? Is that something that is fresh in your mind?
My lord, I said I don't remember. My words here were clear, I don't remember.
Okay.
When I went back, I reflected.
You don't remember?
Yeah.
What?
On Wednesday,
You said you don't remember.
I
what?
did remember other gunshot injuries that I had handled in High Court.
Okay.
But I remember one I had handled in the military tribunal. Yes.
So when you went back, doctor, you reflected and you remembered only the Godi case.
That's right.
Okay. So that your finding in paragraph 4, was it therefore a finding of scientific fact or it was an assumed fact due to absence of information in the postmortem report?
My lord, it was due to absence
It
of
was
information.
assumed due to absence.
Of information, yes.
I have lost count, but I am recollecting that that is the fifth assumption that you are making.
They are not assumptions, my lord.
Are they facts?
They are facts, my lord.
Now, read to court paragraph 5.
My lord, in paragraph 5, I wrote, there is no doubt
There is no doubt.
that the gunshot entry wound was through the right ear, as demonstrated by the powder blackening, as well as the blast effect of the gunshot that caused extensive lacerations of the outer aspects of the right ear.
Doctor, you will agree with me that any person would only make this conclusion that you're making either by looking at the physical body or by looking at the photograph.
That's right, my lord.
I just want to remind you, my good doctor, that by the 3rd of July 2024, when you wrote this report, you had no idea about the photographs. They were given to you a year later by your own testimony. So, that being the case, what was the source of information in this particular paragraph?
My lord, at this point, there were black and white photographs that had been, I think, supplied or something like that.
Please, I advise you not to think. No, by thinking, not that he should not use his head. But this is not, my lord, this is not a speculative process. That's what I mean. Please, doctor, you are a witness. You are a witness. Please, Mr. Jet, let's not go there, please.
When the witness supplies an answer, even when you are uncomfortable, you accept it.
I have accepted it.
Yes, so don't advise the witness to. Much obliged.
Doctor, I am advising you kindly that you are a witness of fact in this court.
That's right.
Not assumptions, not guesswork. So that's why I'm saying, don't think. If you know, you know. If you don't, you tell this court. So let's now proceed from where you ended. So by this time, there were black and white photographs. Is that your position?
I don't remember. I must say I don't remember exactly
where you got this information.
What informed me at this time of this.
You don't remember. So, my lord, we proceed. So you are aware, doctor, that every scientific conclusion must have a proper basis.
That's right. That's right.
But you do not remember the basis for which you made the conclusion in paragraph 5.
Yeah, the facts which informed this.
The facts.
Yeah.
But do you remember having any black and white photographs?
I don't remember I don't remember really whether I had them or I didn't have them.
Do you remember whether you had them at all?
That's what I'm saying. I can't remember.
You can't remember. Doctor, we were here on Wednesday and we advised you to carry your 2 bulky files that were given, because those will actually enable you to recollect. Did you carry them?
Yes, my lord, I have them.
You have them.
Yes.
Do you think they can help you to remember whether you had or you did not have? Because that is your engine for this report.
Yeah. My lord, at that time, I had
now,
not.
my lord. Now.
They cannot help me.
They can't help you.
No, because I made this report before.
Before you got that file.
I got the file. Yes.
Oh. Again, I am moving on.
Yeah.
Doctor, you realize that we are moving from assumptions to completely no basis. So I want you now to go to your next paragraph. Paragraph 6.
My lord?
Read it.
Yeah. It is extremely rare for a bullet that has been randomly fired through the skull to exit precisely through the ear. The converse.
Just read it again.
Yeah.
Doctor.
It is extremely rare for a bullet that has randomly been fired through the skull to exit precisely through the ear. The converse, however, is very common.
So, where did you get the information that the bullet that you were dealing with was randomly fired?
My lord, this is common sense.
You used common sense. Okay. So you will agree with me that the basis for your conclusions in this paragraph is not based on a scientific evidence, but common sense.
My lord, science is based on common sense.
And in this case, you used common sense. Yes?
Right, my lord.
I'm putting it to you, doctor, that by the time KAA contacted you to generate this first report, you were briefed of a case theory that people were fighting in a room and a bullet accidentally got discharged. And you were working through that theory at the time.
I wrote that is speculation. We object to that kind of question. They are inviting the witness to speculate, and my colleague is speculating.
My lord, I'm putting a statement of fact.
To confirm whether or not he had been given a story. All the
That's
witness
you.
has to say. No?
Yeah. That theory was not there given to me.
So, doctor, at what stage? Let me wait. Of course. Now, you agree with us that suicide is targeted shooting. somebody decides that they should shoot themselves. So at what stage did this bullet turn from being a random bullet to a suicide bullet, which is a targeted shooting? At what stage did you change your mind?
My lord, I have never said this was a random bullet. I have never said this particular bullet was a random bullet.
I am moving to the next paragraph.
Okay.
The rest is for brass and bones.
Okay.
Please read paragraph 7.
Paragraph 7, should the exit wound have been through the right ear, then brain matter and bone fragments would have been evident through the wound. But these were significantly absent in the pictures and not mentioned in the postmortem report.
My lord, are we there? So now, Mr. Dr. Nzboa.
Maybe a bit of learning for folks. If a bullet comes through the ear, expect brain matter and bone fragments.
That's right, my
Because
lord.
of where the brain is situated.
That's right, my lord.
We will come to that even more. But for now, Dr. Nzboa, you see, at this stage you have the report who had briefed you about the pictures at this time of writing the report. You had none at the time, but you are referring to them in this report. Where had you picked this information on pictures?
My lord, as I said, I don't remember at that time where I got that information.
Just to be sure that you are clear to court.
Absolutely, my lord.
This report here
Right?
was made for you, and your only job was to append your signature so that your credentials can be used to propel a specific defense theory. You never made this report, Dr. Nzboa, because if you had done so, you would know exactly where you got the information contained here.
I object very strongly. I have my laptop here. The report is here, made by me on my laptop.
Is it your testimony, therefore, doctor, that even though you did not have pictures at that time, there was the possibility of you imagining them and making reference to them?
My lord, that is not true.
What is not true?
That I imagined these pictures in my head.
Did they exist before you when you are making this report?
My answer is simple. I do not remember the source where I got these pictures at that time.
Doctor, let this court rely on your expertise for this fact. If there is evidence presented before you as a pathologist that a body was cleaned prior to post-mortem examination, would you still expect to find things like blood, like brain matter on it?
My Lord, that depends on
If
how
there is
thoroughly
evidence, if there is evidence.
that the body was thoroughly cleaned.
I don't know.
Precisely, that's my
I've just
answer.
told you about cleaning.
Yeah, yeah.
Depends on how thoroughly it was.
The body was cleaned, yes.
So if it was cleaned very thoroughly, you would expect.
You will not expect. But if it was not cleaned thoroughly,
I'm taking you to paragraph 9. I will traverse 8 elsewhere. Read 8. 9 rather.
my Lord,
Yes.
there is no independent forensic evidence described or otherwise to confirm that the wound on the left temporal area was a close contact wound.
Yes.
The authors of the post-mortem report should elaborate on this.
I want you now to read your concluding paragraph on page 3. What did you conclude as to whether the gunshot injury was close, near, or distant?
My Lord, should I read the
Please.
whole conclusion?
No. The second sentence. The court has the report.
Oh, okay. The gunshot was also a close contact considering the blackening of the right ear.
Okay. So the reason you concluded it was close contact was because of what you call blackening of the right ear.
That's right, my Lord. And the lacerations, my Lord.
Now, Dr. Nzubua, I just want to be clear. Do you believe that a bullet entered Henry Katanga's head?
That's right, my Lord.
You believe that?
That's right, my Lord.
And you believe that it exited?
That's right, my Lord.
Read paragraph 11.
The bullet must have moved from right to left, upwards with a slight deviation backwards.
Okay. Hold it there. By use of the word must, doctor, this is confirmatory, done and dusted.
Right.
So by application of this word, you have no room in your mind of alternative possibilities.
Absolutely not, my lord.
Explain a bit what slight deviation backwards means.
My lord, in the slides that I showed here, to me, the entry wound was to the right, in the right ear. But the exit wound was above the left ear and behind it, above and behind. So this means that it moved from right to left with a slight turning at an angle, not a straight angle, not straight line, but at a slight turning backwards. So that's what I mean by slight deviation.
Now, confirm you never physically dealt with this body.
No, I did not.
You only dealt with the pictures, the photographs.
The photographs and the postmortem report.
Doctor, since you never dealt with the physical body, how did you determine those slight deviations backwards, etc.?
My lord, the measurements
You relied on which measurements?
the measurements in the postmortem report.
You relied on the measurements in the postmortem report.
That's right.
Okay. Do you believe in the measurements, in the authenticity of the measurements in the postmortem report?
I do.
They are accurate.
I do. Except, of
Are
course,
they accurate?
some are not.
How did you determine those that are accurate from those that are not?
My lord, when a whole ear is measured and said to be a wound, that is inaccurate. But when a wound is pointed at the back of the head with the measurements, you can see that these are authentic. The positions that were described in the postmortem report, my lord.
Doctor, where is the source of information that the whole ear was measured?
My lord, in the postmortem report here, a wound was described as 3 by 5 by 3 centimeters. This was an absurd wound. 3 by 5 centimeters as an exit wound. Actually, I got alarmed when I read this.
I don't think that it will be surprising for you to be alarmed. But my question so that you don't alarm us. My question is different. Where is the information that the whole year was measured by anyone? Is it contained anywhere?
Yes.
Can you point to quote that particular part where you get the information that the entire year was measured by anyone?
I demonstrated it
Is
in my
it there
presentation.
or it is not, Dr. Tukua?
It is there where they put the real.
Read it to court.
Not in this postmortem report, my lord.
Okay. So where did you get it?
The pictures, my lord, which you sent, my lord.
So you looked at the pictures and concluded that the people who dealt with the pictures were measured in the entire year. Is that what you want this court to believe?
That's right.
Okay. Now, Doctor, this is the final section of this. Your first report. We had to traverse it so that court knows where you came from and how you dived into the second one. By the time you make this report, you are fully retired and no longer a serving pathologist of Mulago Hospital. Just for emphasis, isn't it? That doesn't require a lot of thinking. Is it a fact or not?
My lord, it's a fact. When I signed this report,
I've not
yes.
even come to signing. Please, you were fully retired. That's all I want.
That's right.
Doctor, when you retired, did you hand over the stamp of Mulago Hospital that you used as a consultant pathologist? Or you retained it?
My lord, I have a personal stamp which I retained.
This court knows what is personal and what is not. I am asking about your official stamp which you used as a consulting pathologist, Mulago Hospital. Did you return it to your employer?
I was never given a stamp. I could not return what I was never given.
So you made yours? Did
I
you make
always had,
yours?
I have always had my personal stamp. I have always had my personal stamp, my lord.
Doctor, please confirm that you stamped this report in the capacity of Dr. Sylvester Nzivua, on Zivua. I'm sorry.
Yeah, no, it's okay, my lord.
Yeah.
It's okay.
A consultant pathologist, care of Mulago Hospital.
That's right, my lord.
By the time you are authoring this report, did you have any legal connection with Mulago Hospital?
Yes, my lord.
Tell this court your connection with Mulago upon your retirement.
Yes, my lord. I'm a retired civil servant of Mulago Hospital. That's a legal position.
So that keeps you in permanent relationship with Mulago.
That's right, my lord.
I am unfortunately putting it to you that, Doctor, you are, for all intents and purposes, holding out, and that your representation of your good self as having an address of Mulago Hospital the institution that you had left long before the report amounts to professional misrepresentation.
That's not right, my lord.
My lord, can some interpretation be done before we progress? You can be returning those.
Okay.
In fact, in your area of expertise, one of the yardsticks you use to tell who shot is presence of gunshot residue.
That's right, my lord.
On the hands, I mean the hands, or that of them.
That's right, my lord.
Dr. Nzua, you are our friend. If you're tired, please tell court. I'm considering the fact that you're a senior person. If you're tired, you can tell us.
You can testify while
There's always another day.
Yeah.
Can we still go on?
Yeah, we can go on.
Now, doctor, you mentioned some of the key characteristics for entry wounds in your report.
Call
Yes.
it what? Abrasion?
Abrasion,
Uh-huh.
ring, or collar.
It's called an abrasion ring.
Ring.
Yes. Or a collar of abrasion.
Americans call it ring, but I think you are British. So you are also correct.
Okay.
So my lord,
That's
we
right.
go by
Yeah.
Mr. Nzvoa's term. Ring, abrasion ring.
collar of.
Abrasion.
Or collar of abrasion. The other is presence of an inverted edge at the entry point.
And what? Make it clear?
Inverted edge. Inverted edge
Yes. Going inside.
means that the skin
Goes
is-
inside. That's right.
goes with the bullet inside.
That's
You-
right.
You can visibly see it in most cases. You can see that print, that footprint of the skin going inside. That's what it means.
My lord.
Skin going inside.
Yeah.
Is abrasion ring, does it mean skin moving inwards?
My lord.
Does it mean so or not?
The skin is elastic. Our skin is elastic.
Don't
It
worry.
goes in and
I will
sometimes
now
comes
come
out.
to the details.
Okay.
Does,
So the
is-
first one is the abrasion ring.
Yes.
Yes, the second
Or
is
collar of abrasion.
That's right.
So inverted
edges.
Yes, the edges go inside.
Inside.
That
Thank
is
you.
the second
The
one.
second
Yes.
one. Thank you, Mr. Nzvo. The third is a grease collar, which
As in Greece.
Yes, grease.
Grease.
Okay.
Grease. Collar, which is also called a bullet wipe.
That's right.
Bullet what?
Wipe. Yes.
Yes.
Wipe, like
Yeah,
wipe.
that's true.
That- The fourth that is considered is the size. Size in a sense that the entry is always smaller in dimension. Not always, not in all cases, but in most cases, it is smaller in size.
That's right.
And that I got it from your own notes, actually.
Okay. That's right.
Okay. There are many others, but I can end at those. Let me now go to the key characteristics for exit wounds. The first one is that exit wounds are generally irregular in shape and larger in size.
Generally.
Yes, generally. Correct?
That's right.
The second is the opposite of inverted. Everted edges.
That's right.
My lord, everted, E-V-E-R-T-E-D.
Meaning?
Going
This means that
outwards.
the skin goes outwards. It is the direct opposite of inverted. The third one that is used to describe or detect exit wounds is the rest I will traverse them later, I think. No. It is this thing you call bone beveling.
When we are talking about skull. Okay, yeah.
Is that
Yeah, in the skull. Primary.
bone beveling?
Right.
And then the other common one is bleeding. The exit wound tends to bleed more than the entry wound.
That's not true, my lord.
That one is not.
That's not true.
Okay, so which one bleeds more? The where it enters or where it exits?
It depends on the underlying tissue.
Depends. Okay. Fair enough. May I request, my lord, the exhibits standard along the postmortem report, the photographs. But may I also request the IT to go to where the pictures are in Mr. Mvua's report. Just enter the first picture. Go to the second. Is where the real pictures come. Maybe there. Is it there? That is one. Go to another one. Let's first run through. Shall come to that. Okay. Now we are going to. I'm going to give you this one. Okay. Yes. So. I want you to look at picture B. Picture B. Picture B and picture A. Go to Go to A, please. Go to A. Okay, we are going to use that B. Okay? That particular B. And then you go to A. Doctor, do you look at that B?
Yes, sir.
Yes, the most clear. And A.
Yes.
I am beginning with size. Which of those two, by visual examination, is larger than the other? A or B?
B is larger.
I require no explanations.
Oh.
Just tell what, is it A or B? So B
Is larger
okay,
than A.
than A. Thank you. Now you go to the other A, which is clearer. Remember the A? Can you expand it? Is it that one? Yes. Expand it a little bit. This one taught you how to expand just that the other day. Right. Doctor,
Yes.
there's another A which is more clearer, by the way. Can we traverse another? Huh? The one I said I will use that one. Huh? It is that one. Huh? Okay, fine. We can use that. It is even there. Even there it is A. Even there it is A. Okay. With your visual examination, do you see the flesh entering inward? Which direction did the flesh go?
I think this is what you mean.
Use yours on the screen. Let's use what the court is.
Yeah. Here,
which direction is the flesh
my lord,
going out? Is it inwards or outwards?
it is not clear on this picture.
It is not clear whether the flesh
clear.
is going inwards or outwards.
Yeah. But
please, we are going to go through all of the A's
okay.
in that report. Okay, go to the first one, sir. The one where there is a tape measure. And doctor, if you can't see properly from there, you can even come where we are here. No, the very first one where there's the other tape measure. No? That one. Expand that one. But even there is enough, but you can use the other trick of Edison. But even that is enough. Doctor, are you in position to see that screen properly?
Yes, my lord.
Okay. The skin, can you observe the skin and tell court whether that skin moved inwards or outwards?
My lord, apparently it is inwards.
Okay. So on which side of the head is that wound?
That's on the left side.
On the left side. So following our yardstick, even my judge in the village will tell you that that is the wound which has an inverted edge or inverted edges. In other words, moving inwards. Correct?
Can I guide court?
Correct or not?
I need to guide court.
Now you will first respond to my question, then we shall take your guidance.
Okay.
Any ordinary observer, one need not be a doctor, would look at that photo and conclude that it is the one with inverted edges, the one which moved inwards, correct?
That's right.
Okay. And again, when you went to the smaller, when I first asked you about the smaller and the larger, you went for A. On which side of the body was the smaller wound? Left or right?
On the left.
Left.
The smaller one
Is on left.
apparently on the left
And the larger one?
is apparently on the right.
Yeah. Doctor, we want you to stick into page 7 there. Put the photos aside.
Yeah.
We will keep coming back to them. Put the photos aside and stay in page 7. Of your report, sir. Be interpreting now. I think in the second last bulletin on page 7 of your report. Please read it to court, if you may. The second last bullet, my lord.
My lord, the features of near or close contact gunshot injuries are burns to the skin due to the flame, soot deposition, and tattooing.
Burn to the skin.
Yeah, features of near or close contact gunshot injuries are burns to the skin due to the flame, soot deposition, and tattooing. Tattooing, burned and unburned powder, making their mark.
The next bulletin.
When the gunshot injury wound has only tattooing, this is an intermediate gunshot injury. When the gunshot injury wound has only tattooing, then this is an intermediate gunshot injury.
I just want you to tell the court what you mean by intermediate gunshot injury.
Intermediate is a range of about 50 centimeters.
The one you demonstrated the other day.
Exactly.
Go to the first bulletin on page 8.
A distant gunshot wound will only have the bullet entry wound and will not have other features such as soot deposition or tattooing.
So, doctor, from your conclusions, beginning with the last bulletin on page 7, where I have an entry wound without the burning of the skin or soot deposition, but with only tattooing, then that is
Intermediate.
conclusive scientific evidence that it is an intermediate wound. Is that correct?
Yeah, and intermediate.
Intermediate
Consistent with.
in a sense that the shooter was
Yes.
50?
About, yes.
About 50
centimeters.
centimeters away.
Yes.
From your first bulletin on page 8, where I have an entry wound and there is completely no soot deposition or tattooing, that is scientific proof that the shooter, that it is a distant gunshot
Wound.
wound.
Yeah, that's true.
And doctor, in this case, when I say the shooter, I believe you understand me to mean the distance between the body and the muzzle of the gun.
That's right.
My lord, if that can be clear. You said intermediate is about 50 centimeters away.
That's right.
What about distant?
Distant. My lord, I do not want to contradict myself.
You have no reason to. Just tell us what you professionally know. Can you put a distance to it or not?
Yes, you can put a distance.
Okay, how far would you regard as distant?
My head is now getting crazy, so I cannot. It is getting tired.
Yeah, you can. If you have any documents, just refresh, please.
Yeah. Can I have my report with the pictures?
The one with the one with PowerPoint, eh?
Yeah, yeah.
This one, yeah.
Yeah.
Can be redeeming of the time of interpretation. But it's not matter. Have you seen it?
Yeah, yeah.
Yes. How far? Is distant?
More than 50 centimeters.
More than.
Yeah.
Doctor, it is a fact. Is it not that presence of soot or flames or tattooing depends on several variables related to not just the firearm, but ammunition, distance, as you have already confirmed, and intervening materials like clothing.
Yeah, that's true.
They may also depend on the condition of the target surface. For example, presence of hair on the point of target. Correct?
That's right.
You would not therefore expect to find evidence of flames if the shot was to the head which had hair.
My lord, actually hair burns, and that burning is very evident.
So in this case, doctor, on where there is hair, on what substance would the flame be found? Is it on the hair or on the skin?
That depends on the closeness of the shot. It could be both.
Under what circumstances would it be on the hair
Only if somebody
and
has
not the skin?
a thick hair, very thick hair.
I don't believe you have understood the question.
I thought I did.
Let me repeat.
Okay.
I will ask you about the type of hair.
Okay.
I am asking where the head has hair.
Yes.
Where will you find the frames? Is it on the hair or on the skin? You said it depends. It might be on both.
That's right.
Under what circumstances will it be only on hair and not the skin? You have already told us the three scenarios.
Yeah. My lord, it would be only on the hair if the hair is as thick as this one here. It would be on both if the hair is like that of this council.
Use the one of jet.
It would be on both if it was like the middle council.
Doctor, if the bullet passed through, okay, this, your conclusion, that, my lord, his position,
My lord,
is,
how do we record the council's head now?
that's why I wanted it.
Evidence.
That's why I wanted
No,
it
he
to,
said
I
yours.
wanted him to use jetties.
So what I've recorded is if someone had really thick hair, the flames would be on the hair.
I know.
If the hair was not thick, it would be on the skin. That's what I've not used council's head my jet there.
Doctor, you are the expert now before court. That clarity on thickness of hair is it something that you have proven through practical demonstration, or you have simply read it somewhere?
Common sense, my lord. Common sense.
So I'm correct to say that that comparison of too much hair or small hair has no scientific. Forget about that picture, but don't answer. You can remove if it is irritating him. It might also be prompting his answers. You can just minimize. We are coming back. Doctor, I would be correct to say that what you just told the court about the amount of hair and the effect, you just think about it from common sense, but you are not in position to point to any scientific confirmatory study of fact that would be the position.
My lord, I didn't look at scientific studies of how far the flame would affect the hair and the skin.
You did or you did not?
I did not.
You did not, okay. So, you just based on common sense.
And experience.
But you have no practical experience in gun use. So, on this subject, I don't think it is experience. To be fair to this court.
My lord, I've examined many bodies.
But you only remember two to the head in your entire career. This one and the one of body.
My lord.
Now you are remembering others.
That's not right, my lord. Many of the cases we do not come to court.
Let's first follow your common sense. If a bullet goes through an intervening object like a piece of cloth, you would not expect to find tooth, tattooing, or the other characteristics that you mentioned earlier on the skin, correct?
That's right.
Now I'm first going to follow what you believe. Somewhere in your report, you opined that the bullet went through the right ear, passed through the mosquito net, and hit the ceiling. Does my memory serve me right?
That was not an opinion. That was based on crime scene report.
No. I just want to.
Yes, that's right. That's right.
Did you believe in that theory?
Of course I did.
You did. So that would mean that, okay, did that theory affect your finding in your report? Not theory, but possibility.
That informed.
That informed.
That informed me, yes.
First, I want to tell you that you won't find any theory in that terms in the crime scene report. But if you've found it, doctor, then would you have any professional basis to discredit your colleagues in the manner that you did, that they arrived at a finding of entry wound without these characteristics?
I definitely stand by what I said. To the best of my knowledge, my lord, the deceased head was not closed, the deceased head was not covered. So my colleagues stated they didn't see any tattooing, any soup deposition, any burning. So how did they call it an entry?
Please put back the photo. Doctor, as we get to the photo, you say the head was not covered. Are you referring to being covered at the time of the shooting? Do we understand you to mean that?
What I'm saying,
Are you making reference to the time of shooting the actual photo?
I'm making reference to the time of the postmortem.
Okay, not shooting.
The time of the postmortem.
But all of these characteristics can only be deposited at the point of shooting, not
That's
postmortem.
right. That's right.
So do you know the status of did you establish the status of the deceased at the time, the deceased's head at the time of shooting?
No, I didn't.
Do you recognize that the wound on the left, the hair is shaved?
That's right, my lord.
Does shaving the hair in the manner that is seen in the photo capable of erasing the characteristics in issue? Is it a possibility?
Yes, of course.
Capable of erasing the characteristics.
Yeah.
Dr. Nzuvua, soot can also be washed away either by blood or water.
That's right, my lord.
In the report that you considered, there was evidence that the body was washed before the intervention of police by some people. Did you consider the possibility of those characteristics having been washed away in that exercise?
I was alive to such a thing, but you do not wash away burning. You do not wash away the burning effect of the flame. You do not wash away tattooing.
What can be washed away?
Soot.
Soot. And we have already said if there is no soot. Okay, please.
You do not wash away burning, you do not wash away.
Tattooing.
Yeah. Great. So, you want to agree with my theory
That
that if the entry wound is on the left and there was not a towing, this must have been either an intermediate or distant shot.
I don't agree with you.
I've used the word if.
Yeah.
I'm careful, my lord.
Yeah.
I've used the word if.
Yeah. If
There is no what?
If the entry wound is on the left and there was not a towing, there was no towing and what?
continue.
then it could only have been an intermediate or distant shot.
A possibility. I was alive too.
Very good.
Yeah.
Doctor, if it is a piece as it is in this case, would you sustain a theory of suicide if the shot is intermediate or distant?
Oh, if it was intermediate
Or
distance,
distant.
it would not have been suicide.
It would not have been suicide.
Right.
You want it? I believe, my lord, if they closed there, we shall be safe. Then they open here. Yeah.
Mubipale ebyazoire byahandika ebitandiko bye okukebwa kw'omubiri n'obusigalira bwoleka nti ekifo ekiri ha mubiri kireeterezebweho ekintu ekibaire haihi batu kakusangwa aba ataliwo okwokebwa kw'omubiri kimanyiza nti arasire abaire haraharaho kandi kakuba haba asigaireho emanyikirizo yonka kimanyisa nti arasire abaire ali hara muno abaire haraharaho kandi kakuba haba ataloho obusigalira bwona kimanyisa nti arasire hara muno okubaho obusigalira oludde okwokebwa kw'omubiri biba nibyoleka bisobola kuleterezebwaho tubiretezebwaho emundu yonka baitu
No, 20th they are not available. But since on 22nd, Mr. Kabeda is not available.
Yes, that's right.
Says it's not available.
But the other 4 standing for him. He's done doing re-examination.
I said if our colleagues are finishing, I will give them, but we don't know.
Let us do 19th then. Matter is adjourned to 19th.